time for our first panel. We're going to get this show on the road. Please take your seats. This panel is going to be moderated by Lisa Martins, who's a partner with the Southern California office of Fish and Richardson. She's an experienced trademark portfolio manager and litigator, and we're just delighted that she's both a moderator and a sponsor. Again, Lisa, thank you.
Thank you so much, David. As David mentioned, Fish and Richardson has been a sponsor of the McCarthy Microsoft Symposium now for the 3 years out of 4. We missed the first one. I have no idea how we managed to do that. But I have been just so personally thrilled and delighted to be a part of this for the past 3 years. Each and every year, I'm just so impressed by the caliber of speakers, and that's certainly evidenced by the panel that we have here today. My first year was up at Microsoft in Seattle, and then last year in New York at Time Warner, and now this year at Fox Studios. And thank you so much, Meilon, for hosting us. Such a gracious host. So, as you've probably seen from the agenda, we really do have high caliber topics, and every year, amazing speakers. And I'll just start with the man to my right, who really needs no introduction at all. We've all been reading his 5-volume treatise since basically graduating law school, even if we don't want to admit how long ago that might have been. And he's a senior professor at USF, the founding director of the McCarthy Institute, and the one, the only, Professor McCarthy. Now, what you may not know about Professor McCarthy, and one of the main reasons that he's on this particular panel today, is that he is also the author of a 2-volume treatise on the rights of publicity and the right of privacy. So who more appropriate to really lead us off this discussion and let us know the basics at a very high level of, what are we really talking about today? What is the right of publicity? What is the right of privacy? How does it relate and overlap with free speech issues? And what is it not really? Because there are a lot of times a lot of mixed issues in the case law. So Professor McCarthy is certainly the best person to illuminate that subject for us. And for those of you who have seen me moderate panels before, you know that I love to tell a little fun fact about each presenter as much as I can, at least as they're willing to disclose in a public audience such as this. I feel like if nothing else, it allows you to get to know us a little bit better and may make for some fun, interesting cocktail conversation later tonight after the conference is over. So what you may not know about Professor McCarthy is that he is an avid watercolor painter in his spare time. And not only does he just do this as a hobby, but he's actually won prizes at the Contra Costa County Fair, a lot of C's in that, several years in a row. So very accomplished watercolor painter. And we're happy to have him, of course, every year sponsoring and promoting the McCarthy Institute all over the country. Now, our second speaker, next to Professor McCarthy, is Jeremy Williams. He's the Senior Vice President and Deputy General Counsel at Warner Brothers. As the head of the IP department, he works regularly on copyright issues, trademark issues, IP litigation, including production clearances worldwide. He's taught copyright law and entertainment law at Franklin Pierce Law Center and also at USC Law School. And today, Jeremy's going to talk about the Perfect Storm case. That was a case that Warner Brothers was involved in. Many of you have probably seen the movie. It was a right of publicity case, so that'll be a fun discussion. And he's also going to go through the various tests that different courts apply to right of publicity cases and how sometimes those different tests and the different applications are leading to different results. And we'll talk about some of the split in the circuits later on in the discussion. Our next speaker is Stacey Burns. She's the Senior Vice President and IP Counsel at NBC Universal. She joined NBC in 2005 after having consulted with Universal for many years, all the way back to 2000. Now, Stacy's portion of the discussion is going to focus on the legislative changes in the right of publicity. Again, rights of publicity are really state by state, so there's a lot of change going on and a lot of different application of the law. So it'll be a very exciting and informative discussion to help you all kind of navigate what's been going on most recently. And finally, our gracious host, Maylon Stark, the Senior Vice President and IP Counsel for Fox Entertainment. She's also the Vice President of the INTA as well. Many of you probably know her from her work at INTA. She's responsible for all of the intellectual property matters, trademark, copyright, domain names, and patents for all of Fox Entertainment Group's film production. And her group also supports Fox's television, cable networks, you name it, worldwide. Before Fox, she was also with Disney. And the fun thing about Fox, as many of you have learned, is Marilyn Monroe did many movies for 20th Century Fox back when. So Maylon is going to talk about the recent Marilyn Monroe case, which was a right of publicity case relating to Marilyn's postmortem right of publicity. And one little fun fact about Maylon is that she is the assistant principal cellist in the LA Lawyers Philharmonic. So very accomplished, both musically and legally. And I guess because I was sharing fun facts about everybody else, it's only fitting that I share a little fun fact about myself. And I have to say, it was kind of hard to just pick just one. I mean, I'm a very fun person. So hopefully you'll all learn that. If you haven't met me yet, come up after the discussion or at the cocktail party, and I'll try to share other fun facts. But for today, I wanted to tie it to both LA and to our right of publicity panel, of course. So my little fun fact is that I like to rub elbows with celebrities. And I'm working in San Diego. I don't really get that opportunity very often, but I did see Kevin Bacon yesterday. So that's my claim to fame so far from being here. But my one thing in San Diego was I do a lot of work with Callaway Golf. And they have their golf pros who aren't really quite the Brad Pitt level of celebrity, but Phil Mickelson's kind of a household name. So I did get to do a right of publicity case for Phil Mickelson. And when in talking with some folks last night, they reminded me that I'm probably then the Fox fair and balanced aspect of the panel, because everybody else on the panel is kind of on the defensive side on these right of publicity cases. And in this case, I represented Phil as the plaintiff, enforcing his right of publicity against a Japanese shaft manufacturer who, interestingly, tried to walk the line a little bit on this case, because they didn't use his name and they didn't use a photo of him, but they used his persona or his identity. So we'll talk a little bit about, especially Professor McCarthy will talk a little bit about how the right of publicity really can extend beyond just a person's name or photograph. In this case, they described him. They had a full cover front page ad showing their golf shafts that said the winner of the 2004 Masters used our shafts. And then the golf shafts were labeled PM 702 and PM 902. But of course, once we brought the litigation and said, well, you've described him now all over the page, and you've used his initials, what more do you have to do? This is like, referring to Michael Jordan as number 23 of the Chicago Bulls, where's our tennis shoes? So they, of course, said, oh, no. PM stands for prototype model. This was our prototype, and so that's why we're doing it. Well, the fun thing is, in San Diego, I guess one of the benefits of being in San Diego is that whenever you have a litigation, they have what's known as an early neutral evaluation conference with your magistrate judge. So very quickly, before any discovery is done, you go in front of the judge. Well, this particular judge loved Phil Mickelson. I mean, who doesn't? We're in San Diego. And he loved golf. So even though the case could have been settled probably in about an hour, he kept us there from 9 to 5, mostly, spending time in our room, just chit-chatting with Phil and talking about golf, and then going in the other room and beating up the other side a little bit. But luckily, and we're not going to necessarily talk about these kinds of cases, but luckily the Ninth Circuit has great protection for celebrities and golf pros, and lots of good case law that you've all probably read at one point or another. Such as the Vanna White case, where they didn't really use Vanna's picture or name, but they used this robot turning letters. and some of the sound-alike cases, the Bette Midler case and the Tom Waits case. So we were able to make a very good case for the fact that, anybody reading this golf-related magazine in the golf industry is going to know exactly who this company was referring to. And so needless to say, very quick, very early, favorable settlement, but quick in the sense of we did stay there pretty much till 6 o'clock at night, chit-chatting with the judge about golf, and he was very starstruck. So maybe even as much as I was yesterday with Kevin Bacon. So without further ado, let me turn it over to Professor McCarthy to start talking about the fun world of right of publicity.
Thank you. Welcome again. The first question, of course, on our panel is, what is the right of publicity? My answer is that it's the right of every person, you and me and celebrities and non-celebrities, to control the commercial use of his or her identity. This means that it's an infringement of the right of publicity to use, without a license, the identity of a real person to attract attention to an advertisement or product. By far, the most common situation is the use of identification values. That is, use in advertising or on products. Boy, that's a big picture. Okay. This ad does not directly say that Hugh Hefner is endorsing Tanqueray gin. It just uses his Playboy image leering at the blondes to attract our attention to an ad for him. All right of publicity cases, I think, can be divided into two categories. The use of a person's identity for its identification value, like in this ad, or the use of a person's performance for its performance value. Now, performance value situations are very different from something like this Tanqueray gin ad. One category of performance right cases is when an actor claims he hasn't been paid enough and uses his right of publicity in a film performance to try to stop distribution. And courts have held that this kind of right of publicity claim is preempted by copyright law. A performance value case, as I've said, happens when a performer who authorizes a recording of his or her performance in an expressive work, like a song or a movie drama, if the performer later objects to the reproduction of that recording in an expressive, non-advertising use. I think that should be the concern of copyright, not right of publicity law. But of course, there's an important distinction that a performer does have a valid right of publicity claim if the performance is used without license to advertise products or services other than that performance, unless, as usually happens, the rights were transferred by the performer to the producer. That's your job to write the contracts that say that. So, for example, if Jackie Chan did not assign all his rights to the movie producer, he'd have a valid right of publicity claim against General Motors if they used a film clip of him in an ad for Chevrolets. But the studio could, of course, use that same film clip to advertise that movie and maybe to advertise another movie that Jackie Chan was in. For living persons, as of 2013, either under common law or statute, the right of publicity is recognized in 31 states. For the identity of deceased persons, under either common law or statute, postmortem right of publicity has been recognized as the law in 20 states, 14 by statute and 6 by common law, but most importantly, not in the state of New York. I think the best way to figure out what the right of publicity is to define what the right of publicity is not. It's not a kind of copyright. We all know that a picture of a real person is copyrightable, but the subject matter of a right of publicity claim is not that particular picture or photo of a person. The subject matter is the identity of a human being, and that is not covered by federal copyright law. Right of publicity bears no resemblance to defamation because that requires a false statement of fact, which harms the reputation of a person, and falsity is not an element of a right of publicity claim. Because historically the right of publicity grew out of the right of privacy, there's a lot of confusion still about the difference between the two. Some judges even use the publicity and privacy labels interchangeably, and that adds to the muddle. Like defamation, all types of privacy rights die with the person, unlike the right of publicity, which has, as I said, a postmortem duration in 20 states. What about the tort of privacy and its famous 4 types defined by Dean Prosser? The right of publicity has no resemblance to invasion of privacy by intrusion and disclosure because they require the invasion of something in which an ordinary person has an expectation of privacy. An invasion of privacy by false light is almost a twin of defamation and differs for the same reasons from right of publicity. Invasion of privacy by appropriation comes the closest to the right of publicity because appropriation involves the use of personal identity in advertising, but the crucial difference is this. Invasion of privacy by appropriation causes damage to personal dignity. Injury is measured usually by mental distress. Usually, but not always, it's the non-celebrity who might win this kind of case. But the right of publicity is a property right. Damage is commercial damage to the value of personal identity. So the bumper sticker should read, publicity is to pocketbook as privacy is to psyche. Right of publicity is not a kind of trademark, and of course we know that a name or a picture of a person can acquire a trademark right, but a trademark identifies and distinguishes a single commercial source of goods or services, and the test of right of publicity infringement is not likelihood of confusion. It's whether the plaintiff is identifiable from the defendant's challenged use, because publicity rights concern the identification of a single human being, and that's not what trademark law is about. Of course, sometimes a given plaintiff might well have a claim for infringement of both the trademark and the right of publicity, but they're not inconsistent in any way. There we go. The right of publicity is not a kind of false endorsement. A false endorsement claim under Lanham Act 43A is often a partner with publicity rights in a cease and desist letter or complaint in a lawsuit. They're buddies, but they're very different. Identity can be stolen and used to attract attention to an ad or product without creating a claim of false endorsement. The why is a famous person's name or image used, like in your example. It's used to cut through the clutter of advertising and simply to draw attention to the ad. Look at me. Johnny Depp not only has a Montblanc pen in his right hand, but that's a Montblanc watch awkwardly balanced on his left hand. So I guess that means he's endorsing them. If it's done without permission, there would be 2 separate claims, right of publicity infringement and false endorsement under Lanham Act 43A. But Tiger Woods is not wearing a Tag Heuer watch. Is this an endorsement claim? It's really hard to tell. How can a deceased person be endorsing some product today? Or does this example do nothing more than draw attention to an ad for Longines watches by using a familiar face? By the way, if you can't read it, the words say elegance is an attitude. If there's a postmortem right of publicity in Bogart's identity, and I'm pretty sure there is, then Longines needs a license to use the image in this way. The right of publicity, of course, is, we can all intuit, can't be used to prevent someone's name or picture in news reporting. It can't be used to prevent use of identity in an unauthorized biography in print or on film. And Jeremy Williams will be talking about how courts have gone about balancing this yin and yang of free speech and the right of publicity. Who does the right of publicity protect? I said everybody. And that's true. Both celebrities and non-celebrities. Of course, 99% of the case law concerns celebrities, because usually only a celebrity's right of publicity is worth enough to justify expensive litigation and appeals. But the advent of social media may be changing that. Judge Koh in federal court in San Jose refused to dismiss a class action right of publicity infringement suit that was brought by Facebook users whose identity, that is their name and profile picture, was placed by Facebook on their friends' pages in a sponsored story saying that plaintiff had liked some product or service. For example, if Mary Smith clicks, "I like Stouffer's frozen lasagna," then if Stouffer's had paid for it, Facebook posted on Mary's friends' pages a sponsored story with Mary's name and picture saying, "Mary likes Stouffer's frozen lasagna." The court rejected Facebook's argument that because the plaintiffs were not celebrities, there was no possible commercial damage and no viable claim. The judge emphasized that Facebook CEO Mark Zuckerberg had said that, quote, "Nothing influences people more than a recommendation from a trusted friend." Judge Koh noted that in a society dominated by online networking sites, the distinction between a celebrity and a non-celebrity seems to be an increasingly arbitrary distinction. Judge Koh's decision is right in line with the majority view in the United States and the 100% clear view in California that everyone has a right of publicity. And for the past 25 years, that's what I've said in my treatise, that both celebrities and non-celebrities have an inherent human right to control the commercial use of their identity. That's my introduction. Now let's move on to Jeremy Williams talking about free speech and the First Amendment. Jeremy?
And I was going to say, actually, Jeremy, before we start, one thing that the audience might be interested in knowing about the Fraley versus Facebook page, in case you want to fill out your online forms and claim your $10 out of the $20 million settlement that Facebook ended up paying. Most of the money actually went to various organizations like the Electronic Frontier Foundation, and they set aside exactly $10 for every Facebook user who was an authorized claimant. So I'm just curious, a show of hands maybe, who wants to take the time to fill out those class action papers to go and get your $10 in case you liked a product, for the past 6 months or so?
Maybe they don't even know if they were the subject of a sponsored ad, unless their friend said, "Hey, what's this all about? Why am I getting this?" By the way, also the first proposed class action settlement was rejected because it provided $0 for the class members and a lot of money for various organizations and the lawyers. And the judge said, "No, you gotta give them something."
Oh, so $10, that's all you need. That's the minimum threshold.
$10 a piece, yeah. We don't know what the multiplier will be.
Oh, great. Well, go ahead, Jeremy. Take it away with
Good
the
morning,
various
everyone.
tests.
I'm going to talk about the clash and relationship between the right of publicity and the First Amendment. And that's obviously of real importance to movie studios and is a part of our daily life. And I've had the privilege of working with Tom McCarthy on some of these matters over the years. And a few moments ago, Professor McCarthy said, if you use a person's likeness in a watch ad, that's a pretty good instance of the violation of the right of publicity. But if you use a person's likeness in a movie, that's a pretty good instance of it not being a violation of the right of publicity. And that the courts would have seen it as simple as that. Unfortunately, there has been an extraordinary amount of confusion in the cases, different tests in different places, differing results on the same facts. If trademark law is designed to prevent confusion among consumers. I think right of publicity law is designed to create confusion among judges, and that's what's been happening. It may not always have been like that. In 1979, a case was decided by the California Supreme Court that I think put the doctrine and the relationship between right of publicity and the First Amendment on a pretty good course. And so it was for 21 years until 2001, when the same California Supreme Court, different judges, I suppose, made a decision that completely confused the doctrine that that same court had established in 1979. The case in 1979 is the Guglielmi versus Spelling-Goldberg case, better known as the Rudolph Valentino case. And it involved a suit against Spelling-Goldberg that had produced a television motion picture biography of Rudolph Valentino. The heirs of Valentino brought a lawsuit claiming it violated his right of publicity and other causes of action. In the opinion in that case, Judge Byrd laid down a fairly simple, common sense distinction, a kind of a categorical test. And what she said was that if it's an expressive work like a movie or a book, to say that it violated the right of publicity would violate the First Amendment free speech rights of the producers. It had been held by the Supreme Court long before that movies like books were entitled to First Amendment protection. She said, on the other hand, and this was in relation to a companion case involving Bela Lugosi, if the person's likeness is used on coffee mugs and swizzle sticks and other kinds of merchandising products that were not expressive works, that would not violate the right of publicity. Now, I think that was a fairly common sense test. It seemed to fit the notion in the statute that if you used a person's likeness in an advertisement or on a product, that it would violate the right of publicity. In a sense, she was saying a motion picture, a book, these are not the kinds of products that are intended by those statutes, and if they are, that would violate the First Amendment. Now, this wasn't a perfect test. The plaintiffs argued that it wasn't really about Rudolph Valentino, that it was about a fictional Italian movie star, because there were a lot of fictional elements in it, and that they were just using the name to attract attention. The court said, well, as long as there's some minimal relevance, some minimal connection to Rudolph Valentino, we're not going to be the judge of that. That's enough. And there was a holding for the defendants in that case. It was recognized, I think, by lawyers in the field that that categorical distinction had some rough edges. For example, if someone had a coffee mug or a T-shirt in a political campaign that said, don't vote for Richard Nixon, that probably would not violate his right of publicity simply because it was on a coffee mug or a T-shirt, even though that was ordinarily the kind of merchandise that would not get First Amendment protection. But that could be dealt with. There are always, gray cases that need to be decided in that way. But I think that distinction was basically working for lawyers advising their clients. Then came the Comedy 3 case. I'm going to have to assume you're seeing the same thing I'm seeing. And this was a case in which an artist made a drawing of the Three Stooges. And interestingly, he reproduced the drawings for sale in lithographs, and even better from the point of view of establishing an interesting case, on T-shirts. Okay. So looking at the Valentino case, this was one where it wasn't surprising that the lower courts found a violation of the Three Stooges' right of publicity. They were put on T-shirts, that was a product, it was merchandise, end of story. When it went up to the California Supreme Court, ironically, you had a very pro-First Amendment court. And it made a decision that was designed to foster free speech, but which I think arguably has had the opposite effect, or at least confusing it enough to create a chilling effect. When it went up to the California Supreme Court, I think some of us who were interested in the field said, aha, what they're probably going to do is say that the lithographs, being just works of art, are going to be protected by the First Amendment, but the T-shirts won't be. And that would be a fairly interesting result, a little bit of a clarification. But instead, the court, deciding to be very pro-First Amendment, said, wait a second, anything can be a medium of expression. There's no reason why an artist can't express himself on a T-shirt or a coffee mug, or I guess a swizzle stick, as much as in a movie or a book or in a play. And so the traditional test, coffee mugs versus books and movies, even lithographs versus T-shirts, was rejected. So the court essentially had written itself into a corner. What was going to be left then of the right of publicity if I could express myself on a coffee mug or a T-shirt? And so they decided that they needed a new test. And borrowing from copyright law, they came up with the now widely applied and infamous transformative test. And what it said was that the First Amendment would protect the artist, even on a T-shirt, if the drawing contains significant transformative elements. It won't protect it, and I quote, if the depiction or imitation of the celebrity is the very sum and substance of the work. It then looked at the drawing that Mr. Satterup had made, and it said, we don't think that you've added any significant transformative elements as an artist. This is just what they called a mere celebrity likeness. In a sense, it gave him an F in his art class and affirmed an award that included attorney's fees for $225,000. Oh, that he was just a better, more transformative, more creative artist. Okay. Well, now you can judge for yourself. That's the drawing. Now, I don't pretend to be an art critic, and Oliver Wendell Holmes, long before, had warned judges not to be art critics. I think this is a reasonably transformative picture myself. We could probably get 20 art professors to write essays about how brilliant it is and all the meaning and pathos or whatever it adds to the images of the Three Stooges. Now I want to show you another thing. Imagine this is present day and that this person is a celebrity. My question is this a mere celebrity likeness? Now, Vermeer worked on this painting, it's estimated, because that was his style, for about 4 or 5 months. We don't know what this person looked like. Some people think she looked a little like Scarlett Johansson, but I don't know. But I think it's pretty certain that he nailed it. This is probably a perfect likeness of this person. But I would say if you compare it with the Three Stooges case, Vermeer would probably lose, okay? And the fact that the painting is worth, I don't know, $500 million is probably not sufficient to establish that it's truly transformative. Now I'm going to show you a drawing that clearly passes the transformative test. Okay, now I did this myself. And I think an interesting legal issue is, does it matter for the transformative test whether or not I actually could have drawn a mere celebrity likeness, or that this is really the best I could do? Now, the truth is, this is the best I could do. I now have a First Amendment right, it seems, that Mr. Satterup, the far better artist, doesn't have. There's something wrong with that test, isn't there? But I don't see any particular counter-argument that this is clearly not a mere celebrity likeness. Well, I suppose you could say, if I just put it on the T-shirt, since nobody else could recognize it as Cameron Diaz without her name, she might still have a case. I recognize their arguments on the other side, but I think it makes the point. It also raises some other difficult issues, which is, what is the scope of this test? Does it only apply to art images of celebrities? What has to be transformed? Is it just the likeness? What if there isn't a likeness? What if I am writing about someone? What if I'm portraying the person in a film? Does it matter whether the actor looks like them or not? Am I better off if the actor does not look like them? Because then I can say I've transformed it. Okay, suppose I cast, Bruce Willis to play Abraham Lincoln. Is that more transformative than what happened in the Spielberg movie? Does the whole work count? Now, I think it's the position of movie studio lawyers like myself that when we're portraying someone in a film, you shouldn't just look at whether Daniel Day-Lewis looks like Abraham Lincoln, okay? I think Lincoln is beyond the statutory period in almost all states. Thomas, is there one where it's not, maybe? Is there a perpetual one?
Maybe
Tennessee?
Kentucky or Tennessee,
Yeah, so the heirs of Lincoln maybe bring a suit soon. Or is it the whole work? Wasn't Lincoln as a personality transformed in the recent film? We think the answer is certainly yes. Now, the case law has dealt with that. This is a case that involved a lawsuit against DC Comics. How's my time? I don't know.
Oh, I'm not keeping track.
Anybody keeping track?
Are you keeping track?
Am I okay? This was a case brought by the Winter brothers. Does anybody remember Johnny and Edgar Winter, erstwhile rock stars? That's a picture of them on the left of the screen. And there was a comic book called Jonah Hex that DC Comics, our affiliate, created. And in the comic book series, they created characters called the Autumn Brothers. And there's a picture of the Autumn Brothers at the bottom of the picture of Jonah Hex. The Winter brothers sued, claiming that their right of publicity had been violated. And this went back and forth through the courts, eventually ended up in the Supreme Court, where it was hoping to clarify or reapply the Comedy 3 test. They looked at it and they said that clearly this was a transformative likeness, okay? And you can see that it is. It's even more transformative. You could see the bottom of the Autumn Brothers, who look like lizards from the waist down. But one of the questions of the case really raised was, how much did that matter? Suppose it had looked more like the Winter Brothers. Is it about the whole work or just about the likeness? I think people differ on what this case meant in that regard, but I think it opened up the notion that where something is in an expressive work, beyond the picture itself, that's a real issue. What are you looking at, the whole work or not? The courts have simply differed on what's transformative or not, and I'll give you one example and then I'll move on, which is right now there are two virtually identical cases in two circuits in which the district court judges have basically looked at the same thing and come to different conclusions, saying one is transformative and one is not. They're both suits against Electronic Arts for these college football simulation games, both involving suits by players who are claiming that their likenesses and identities were used. And in a case called Hart versus EA in the New Jersey District Court, the judges said, I think the likenesses are transformed. I think that the work as a whole is what needs to be looked for, so it's a transformative use judgment for the defendants. In the Northern District of California, a judge looked at exactly the same thing and said, number one, I don't think the likenesses are different, so I think it's not transformative. And number two, I'm not going to look at the work as a whole. Judgment for the plaintiffs. They're not on appeal to the respective circuits. The circuits could come out differently. It's a danger, I think, that illustrates the problem of having the courts have an unclear test about what has to be transformed and setting themselves up as art critics to decide whether the transformation is enough. There's a new test that's developed, and it's really, in a sense, a trademark-related test. Do I have the right slide up there? Yeah. The Rogers test. It came out of a movie called Ginger and Fred, and it was not about Ginger Rogers and Fred Astaire, but about two dancers who were something like that, and the producers decided to call the movie Ginger and Fred, obviously for evocational reasons. The Second Circuit looked at this, and there was both a 43A and a right of publicity claim involved. And they applied a two-part test to both claims, and I have the different words here, but it's essentially the same test. They said if there is minimal artistic relevance, or if it's not wholly unrelated to the plaintiff in this case, which was Ginger Rogers, and if the use of the identity is not explicitly misleading or a disguised advertisement, then the defendant's going to win. This is not a transformative test. This is a minimal relevance test, not unlike Valentino. And if it's not explicitly misleading, then we're going to hold for the defendants. And this is going to work whether it's a 43A claim or whether it's a right of publicity claim. And you're starting to see the spread of this now. It's been brought into some of the other cases around the country. The movie studios have been writing about it in amicus briefs. And it really eliminates this kind of artistic judgment. And in a way, I think, returns us back to the relevance test in the Valentino case. Was it relevant? Was it about Rudolph Valentino in some minimal way? So we'll see where that goes. I want to talk briefly about the perfect storm case. How many minutes do I have left?
Not much.
About
Not much.
3, yeah.
3.
Take your time. I'm talking about statutes. How boring after this.
Well,
So take
I want to give you your
all the
time.
you need.
The perfect storm case, I'll be brief, illustrates a true clash between First Amendment and right of publicity, and how the right of publicity can be, in a sense, abused to try to attack what seems like a fairly clear First Amendment case. And it also raises questions, which I know you'll talk about, Stacy, about whether there should be just a categorical exception. Many of you probably either read the book or saw the movie. This was about a fishing boat that was lost at sea in a big storm. All of the fishermen on the boat died, or presumably died. There was no one really to tell the story, so there was necessarily going to be a certain amount of fictionalization and speculation in both the book and the movie about what happened. The heirs of Dale Murphy, played by John C. Reilly, and Billy Tyne, the captain of the ship, played by George Clooney, brought right of publicity cases against Warner Brothers in Florida, claiming that we violated the descendable right of publicity of these fishermen. We defended on the ground that this was an expressive work, that it was entitled to First Amendment protection. We also defended on the ground that under Florida law, the right of publicity statute was not meant to apply to expressive works like movies. And the federal district judge agreed with us on both counts. She said, I'm going to interpret the statute in a way that's consistent with the First Amendment. I think that's what the Florida courts would do. There was one Florida case that actually had said that. So I hold that it doesn't violate the California statute. But in any case, the Florida statute, thank you. But in any case, even if it did violate the statute would be unconstitutional finding for the defendants. We went up to the 11th Circuit, the plaintiffs appealed, and the 11th Circuit, rather than deciding it on First Amendment grounds, said, let's do it statutorily, and sent it to the Florida Supreme Court for an advisory opinion. So we went to the Florida Supreme Court, made the same arguments, and the case, the court found the same thing. It said that the statute should not and does not. We hold that it won't apply to a movie, because if it did, it would violate the First Amendment. Then we went back to the 11th Circuit. All this was very expensive, as you can imagine, and the case was dismissed. The one thing I want to mention about that before finishing is, I said it was something of an abuse, and here's why. Generally speaking, as I think most of you know, defamation and invasion of privacy claims are not descendable. Because the people who would have been the subject of the defamation or invasion of privacy were deceased, those claims would not lie under Florida law. If you read the complaint, particularly the complaint about the captain, Billy Tyne, it really reads like a defamation claim. It claims that the movie portrayed him unfavorably, in a false light, in a negative way, that he didn't behave the way he did. It made him seem like he was maniacal and suicidal and led to the deaths of all of his shipmates. Because they couldn't bring a defamation claim, they used the right of publicity. I don't know whether they realized that they'd probably lose under the First Amendment or not, although that result seemed hopefully inevitable. But they made the argument that because we made deliberately false statements about him, because the movie was to some degree fictionalized, we don't really know what people said on that boat that got destroyed, that we weren't entitled to First Amendment protection at all. Essentially, they were arguing, trying to use the defamation logic that deliberately false statements are protected by the First Amendment, in a sense that fiction, at least in a right of publicity case, wasn't protected by the First Amendment. And Tom McCarthy and I worked on that together. I know that question of falsity in the right of publicity is a particular pet peeve of yours. Yeah. You mentioned it briefly. Maybe you can talk about it in a few minutes. But it was an example of using the kind of end run of falsity to get around the lack of a defamation claim and to try to use the right of publicity in that way. Fortunately, it didn't work. I don't think there's any legal basis for it. But the perfect storm was an illustration of a case where we had to fight the case. We refused to settle. I remember a conversation in which the plaintiff's lawyer said, "So what are you offering our client in settlement?" This was before the case was filed. And we said, "We're not offering him anything," because we felt we really had to defend our right to make an expressive work like a movie based on these people, with or without their permission, in this case, without. So that's probably a good segue, Stacy, into your talk, because I think this is a case where the courts, having confused the issues so much, it probably does require some legislative help.
Right. I think that's what, that's really, I think, what people are looking for. And I should say, by the way, my comments are individual, not the company's views. But what we're looking for here, I think, and I think we have a lot of sympathetic people in the audience, from a clearance perspective, you want some clarity. And you have a lot of, you have mounting confusion in, with the tests. You have, Warner Brothers had to go through 3 levels of courts because you have this notion of, let's not reach constitutional issues unless we need to. But that doesn't work very well when you're talking about things like expressive works. And so what you have is you have a chilling effect at the clearance stage that comes. So maybe there's speech that remains unuttered. Maybe there are changes that you're going to make. Maybe you really want to be able to reduce your risk to 0 for a particular kind of use just because of the potential revenues associated with that use. Right? Major motion pictures obviously are a different story, but you still don't want to be inviting claims and things that are going to take the resources of the company to defend, money, as well as, the time of executives, having to justify artistic decisions because you have artistic relevance. Feels like something, certainly the Second Circuit intended that to be an extremely low bar, but you could, wind up with another court that sees it as an invitation, to kind of look into the creative process that people went through and why they decided to make the decisions that they did. All this is really quite invasive and feels very inappropriate, right, when you're talking about fully protected expressive works. Now, the First Amendment reaches beyond expressive works. There is First Amendment protection that attaches to commercial speech. That's kind of beyond the scope, I think, of certainly my talk today. But there is a core. There are core expressive speech. There are core instances of expressive speech that really should not be dragged into, these conversations, in the courts, and be subject to sort of differing tests. And all the different states, and all the vicissitudes of litigation. And so when we come to legislation, which is increasingly happening in the different states, you're seeing more and more statutes being adopted, or in the different states. A real focus that I believe is appropriate, and I think is broadly understood to be appropriate, is going ahead and creating just clear exemptions for core expressive works that there really should be no conversation about. So that you should never see a claim about it. You can go with confidence, when you're clearing, and you don't have to be counseling about risk of, who knows what might happen in an odd case risk. An example which was probably very familiar to a lot of you of the transformative confusion, is the No Doubt case, right, that just came down, that seemed to say something completely different from what the California Supreme Court had even said on that. So even when you think that some clarity has developed, you can still wind up with a different court taking the same language and, interpreting it differently, and Jeremy gave some great examples of that. So I just have a few things that I just wanted to mention that, we are this is not the right one. No, I think maybe it was put in the wrong order.
All the way to me.
No, sorry. Oh, this is it. Okay, so these are just some things, all right, that are worth looking at in order to create some clarity when statutes are being developed. And the one question obviously is, or what are the definitions, right? What is the reach of commercial purpose? And the definition, I think, is one of the things that was considered from the Perfect Storm case that did not have any express exemptions. And I think the court there, the Florida Supreme Court, said this isn't captured in the first place. And then went on to, luckily, go on and also choose to discuss the First Amendment. And did a fine job with that. But it's not terribly clear, like, what some of this language encompasses. So you'll see very often, references to commercials. It's a commercial purpose, a commercial use, on all, goods and services. And you just, have no, it's intended to be broad when these are created. And so there can be a conversation around the definition and trying to put some parameters around that. But I think the more useful approach is to look for express exemptions. So you categorically are exempting, books, films, other audiovisual works, the lists that people can agree on, right, that should just be kept out of the statute altogether, is a subject of a lot of conversation. And so how long will that list be? What will those descriptions look like? An important component to this is generally is also advertising and promotion of those works. So if you can use an image or name or likeness, persona, it can get awfully broad. In a work, you should be able to use it in the advertising for that work as well. And so, because of the use of the word commercial, you want to be careful in the exemptions, that you're making it clear that you're now not going to have to cabin your advertising for this expressive work. Because obviously the advertising itself is also expressive. It's connected to the work, and it's promoting the work. So that is something else that that's important that people will look at. And in general, you can tell me if you disagree, there tends not to be an enormous amount of controversy over these kinds of exemptions. They're considered so core that there isn't a lot of opposition. As I recall, New Hampshire was an exception to this a couple of years ago. I think that the governor finally had to veto the proposed legislation because there were some legislators who apparently were offended that the local newspaper could run the politicians' pictures without their permission, right? All right, and so these sorts of things are the reasons one needs, right, these express exemptions here. Because I think they saw it as a privacy issue, and there are all these different ways that you can look at publicity, right? And do you see it as coming out of the process, the right of privacy, the right to be let alone, kind of right of publicity? Do you see it as the commercial, right of publicity? Is there some of both in all of this? But this was clearly a statute that was designed to address the commercial right of publicity, but there was resistance to including these exemptions. As I said, I think that's unusual because these really should be non-controversial exemptions. Now, some other issues that have, and Jeremy, I don't know, is there more you'd like to kind of add to that? But some other issues that come up that with some frequency in looking at these statutes are that all help in terms of, from a clearance perspective, in trying to get some certainty, right? So if we're outside of the core exemptions now, and say you have a piece of merchandising, and I think the day is going to come where some of those uses are going to be challenged as well, the right of publicity claims on First Amendment grounds. But as I said, that kind of exceeds the scope here. But I think this whole area has many chapters still to be written. So in addition to these tests, we still have a lot of other issues, perpetual rights of publicity, things that go 100 years, post-mortem. The notion of post-mortem right of publicity at all is really controversial in some quarters. When you have, if you think about the notion that you really can't defame the dead, so you can say anything you want about somebody, but then you can't kind of use them arguably, right, in the watch ad. And so I think those things are the subject of lots of conversations. The core areas for me are the things that we've been talking about, however, are film, television, other kinds of audiovisual works, and the advertising and promotion of those works. But I do think there are a lot of issues that are going to be around it. But we're interested in seeing a registration system, right, in the put into the statute. So if there is a right that's implicated by a piece of merchandising, you have someplace you can go, right, to get the rights, right, that somebody may be claiming. And if you don't have a system like that, then you have this open-ended notion of there could be multiple heirs, you don't know how many, you don't know where they are, you don't know how to find them, and are they going to agree with each other, right? I mean, if you want to move things forward, you just want to know where you need to go. And so, again, I don't think that's generally a terribly controversial point. I mean, some people would like to have zero barriers to entry, I suppose, but in general, it just seems logical. It seems to make a lot of sense to do that. The issue of domicile is one that's quite current. So there are a couple of states that have what I call all-comers statutes. It doesn't matter if you're a resident of that state, if you are an heir to a person who died in that state, you can still come to that state and sue over something that occurred in the state. And that's very unusual. Generally, there's a connection there's some kind of a domicile connection, which is also very helpful, right, from a certainty perspective. So you can find out where somebody was when they died. The heirs will have registered as part, in the state. And, it's very state-based law, which can be very frustrating, of course, since you have 50 different states, but still, you know that you're working within a particular jurisdiction. Washington is one of the states that has took an all-comers approach. And that's in the Jimi Hendrix case, the district court in Washington struck that down and said it's unconstitutional, right, to have this, not have a limitation, a domicile limitation. And the court thought that it violated both due process and sort of the full faith and credit clauses of the Constitution. And that case, and it has a lot of issues in it. I believe this is one of the issues that's on appeal. And that case is set for hearing, I believe, on March 7th by the Ninth Circuit in Seattle. So that could make for very interesting listening. That the hearings are made available on the Ninth Circuit website in about a week's time. And that could be a very significant ruling when it comes to that particular issue. Another issue that comes up, and that is very significant from a practical perspective, is will the remedies under the statute be exclusive or will they be cumulative? So will you still have a common law right of publicity in a state that has a common law right of publicity already? Or will the statute supersede that, preempt it on a state basis so that you're only dealing with the statute? Again, from a clearance, a practical person's perspective, you want as much certainty as possible. So if you're going to have the statute, you prefer to have a statute, I would think in general, that is exclusive. So everybody knows what the rules of the road are and everyone's working under the same set of rules. And you still have the Lanham Act aspects to the whole thing that obviously is not going to get pulled in through state law preemption, but you at least would create just kind of a unified body of law within the state itself. So the other thing that I put in the materials, and we can go ahead and, but I thought you were going to have the materials, but I'm not sure that's how they did it here. So I'm just going to kind of flip through this. I just happened to pick Ohio because Ohio has a state that had listed the express exemptions and also dealt with a few of these other issues. Right, so you can see here, this is the express exemption part of the statute. And it does talk about the advertisement and commercial announcement for any of the foregoing, which is an important element to this. And this is really just a lot, these are just more specific exemptions. These will tend to differ from state to state, although the core tend to be the same. And number 6, I find an interesting notion, and people may have different points of view on this, but I have never really thought there's any value to including an exemption that says that any uses that are constitutionally protected are exempt from this. Okay. It may be that a particular state constitution somehow will recognize the ability of a legislature to override a constitutional protection in a state constitution. It seems unlikely, but I recognize the possibility, but certainly not over the U.S. Constitution. And I have seen situations where people will try to have only that language, right, in a statute. But again, it's just very question begging. It doesn't really do anyone any good. So it's nothing that I think you're generally better off without that kind of language.
Okay, Stacy, we've got about 10 minutes left, so if
Okay.
we can squeeze
So
Marilyn
that's
Monroe
fine.
in.
We're going to move on to Maryland.
Well, the good thing is there really should be a segue here. And the segue would be that a lot of times when you see these right of publicity cases come up, and when you see the legislative efforts come up in the states, the legislatures are trying to correct what they think went wrong in the courts. And so this case actually combines a little bit of, obviously the original principles that Professor McCarthy talked about, but certainly the different kinds of cases that Jeremy talked about, and then some legislative action sort of thrown into the mix in the middle of the case. This case is about Marilyn Monroe, and you've probably, many of you in this room, especially the ones who are at studios, have read this case, I would imagine. And it really kind of focuses on Marilyn Monroe's postmortem right of publicity and where she was domiciled at the time of her death. So as many of you know, and is certainly is true here, deceased celebrities are big business. In 2011, Forbes named Marilyn Monroe, I think, as number 3 of the highest earning deceased celebrities in the world, earning about $27 million that year. So there's a lot at stake for these kinds of cases. So this one goes back several years. Back in 2005, Marilyn Monroe's estate and this agency, CMG, who purported to own her postmortem rights of publicity, sued these entities who were using her photographs to advertise the sale of different pictures of the actress. So the defendants actually responded by filing a declaratory. That suit, the original suit, was brought in the Federal District Court of Indiana, and then the defendants actually sought declaratory relief in the Central District of California, and those actions were actually consolidated in May of 2007. The District Court of California actually granted summary judgment for the defendants. So let's kind of look at the facts, because they're kind of fun. Following her divorce from Arthur Miller in 1961. I mean, does anybody else, by the way, think that it's just amazing that the same woman was married to Joe DiMaggio and Arthur Miller in a very short period of time? I mean, I think that's kind of fascinating. Two completely different kind of men. Anyway, she executed her will in New York in that very same year, and then in the spring of 1961, she actually moved to California. And first she lived in a hotel, and then she rented an apartment, and then in February of 1962, she bought the house in Brentwood that you see in the lower part of this slide. And she began shooting the film Something's Gotta Give that spring for none other than 20th Century Fox. So she continued to maintain her New York apartment throughout this time. And then, of course, on August 5th, 1962, Ms. Monroe was found dead in her Brentwood home. So at issue in that case was she domiciled in California or New York when she died? And did she have a post-mortem right of publicity then that could descend on to the estate and CMG? Well, the district court spent a ton of time examining her will and probate proceedings in detail, but suffice it to say that they found that for over 40 years, Ms. Monroe's estate had argued that she was domiciled in New York at the time of her death, and that was principally to avoid paying California estate taxes. So they had filed affidavits with the tax appraisers. They had argued that all of her actions prior to her death showed that she meant to keep her domicile in New York. Her apartment was kept. It was not sublet. All her personal effects remained in the apartment. Her maid was kept on staff to oversee and maintain that residence while she was in California shooting this film. Obviously, the problem is that New York, as we all know, does not recognize a postmortem right of publicity. And so now this was going to be an issue because you have $27 million a year at stake. Well, California does. So now the executors are arguing, oh, no, it's, California law should apply, and there is a postmortem right. And she had this beautiful home in Brentwood that you all see here. Okay, well, in granting summary judgment for the defendants, the court found that at the time Ms. Monroe died, New York, California, and even Indiana, where the original case was brought, none of them recognized a postmortem right of publicity. And California didn't even create that right until 1984. So no matter whose law you applied, there was no right that could be passed to anybody through her will. All right, California state legislature, being the home of Hollywood, didn't love that. So you see here, California State Senator Sheila Kuehl, and she introduces a bill to amend the California right of publicity statute to say that there is a descendable right, postmortem right of publicity, and it doesn't matter when the person died. And if they died before, or on the day of the enactment of the statute, the day after, it doesn't matter. So for those of you who don't know, Sheila Kuehl was actually a child actress in the 50s and 60s. We seem to be on that trend here in California where we hire former actors to be our politicians. But, or I guess they elect them. But she's best known for her portrayal as the irrepressible Zelda Gilroy, I think it was, in the CBS television series, The Many Loves of Dobie Gillis. So you see her in that role here as well. Well, based on the passage of that bill, Monroe's estate sought reconsideration of the district court ruling. And that motion for reconsideration was granted. And the district court held, well, the right of publicity statute as amended would permit her right of publicity to pass to the estate through her will if it's California substantive law that applies, right? So then, of course, they go back to examine the domicile issue again. And yet again, they find summary judgment for Green and the original defendants. Okay. So then we appeal to the Ninth Circuit. And in the Ninth Circuit, they just issued their opinion, I think, last August, right? And they affirmed the lower court's holding. And the issue before them was really whether or not, of course, this estate owned the postmortem right. And they kind of went through a very lengthy analysis of judicial estoppel, which I will not recount for you now. But they said, essentially, you know what? It's too late. You guys said for a very, very long time you didn't want to pay California state taxes and that she was domiciled in New York, and you can't really change your mind now when it suits you. So no longer is there a right of publicity postmortem for Ms. Monroe, And I find that that's very interesting timing, in part because there's a new entity that's controlling her rights. And it's this group NECA now, as opposed to CMG. And NECA actually, in the estate, they actually own trademark rights for Marilyn Monroe. So they have it in block script, and they also have it in her signature style, which you see here. And so I think that this is going to raise a lot of interesting questions because, of course, with the uses of her images, right, you all have maybe your traditional copyright images, copyright issues that come up. There's no longer this postmortem right of publicity, but they do have the trademark rights. And there is, I think, a trademark doctrine that is not called on very frequently, but that could maybe see a new life in cases like this, right, which is the doctrine of equivalence. Oops. Sorry, missed my slide cues. And you'll have to forgive the misspelling of Ernest Hemingway's name. I think that might have been a spell check error. But if you, and I'm sorry that Bob Marley's there as well. A little surprise for me. But you know, there is a TTAB case involving the mark Sloppy Joes with the image of Ernest Hemingway. And there are a lot of other cases that had this doctrine of legal equivalence too, but you don't see it used very often, right? And the TTAB in that case said, you know what, you can't register that mark because there is somebody else who has a registration for the mark Hemingway and Hemingway's for bar and restaurant services. And when people see this mark, they're going to really identify that with Hemingway because of the prominent use of his face. So I think that it'll be very curious to see what happens and how NECA goes about their business as we go into the future. This is several examples of some current licensed products, some of which have her name, some of which only have her first name, some just don't have her name at all and just have images of her. And so, you know, will these things be permissible without a license in the future? Will some of them be permissible? Will none of them be permissible? And I think those will be sort of the questions that we see lying ahead for that particular deceased celebrity.
And
Did I make it in?
Yeah.
You did. In fact, we have exactly 2 minutes left, I've been told.
But also,
So
just
if there's
if I could
one
do-
burning comment, question,
Okay.
anything you guys want to leave the audience with, now is your chance.
It's not a burning comment, but just a postscript. There have been efforts over the last several years in the New York legislature, right, to pass a postmortem right of publicity, and I'm sure that the Monroe estate has figured into that, so it will be interesting to see with the change whether we see that come back as well, so. But nothing burning, sorry.
Well, no, and apparently you're all so very interesting that we have been allotted exactly 5 minutes now, a little bonus 5-minute round for questions from the audience. And there's a microphone right here with Russ standing at it. Russ, do you have a burning question to kick us off?
I do have a burning question. The question I have is, we heard a lot about the different state statutes that exist right now. What are the chances, if any, that there's going to be any type of harmonization of the right of publicity laws in the future, or federalization of a right of publicity law?
Well, I can say that because I served on an INTA committee some years ago, and there was also parallel efforts in the American Bar Association, and I know my committee spent a lot of hours of very expensive lawyers, and we put together what I thought was a terrific federal right of publicity statute, but it was cut off at the pass because the people who were at that time were running INTA said, no, we don't want it, we don't need it, and it's dangerous stuff to have a federal right of publicity statute. Maybe looking to what happened to trademark dilution law, which was ignored under state law until there was a federal law. Then it took off like a rocket. So there are political currents flowing here in favor of and against a federal uniform statute. I mean, personally, I think it would be good for clearance purposes if you had a single nationwide law you could look to. But of course, the question is, what will that law say?
Exactly. Well, the follow-up to that, I would imagine that if you're trying to extend any of your right of publicity rights into foreign jurisdictions, making arguments about what you think the law should apply in those jurisdictions awfully difficult when in the U.S. we don't even have a settled law. So that was really the gist of my question. And I imagine that it is a difficult conversation to have with the likes of Tennessee, with the estate of Elvis, and California with the estate of Maryland. So finding agreement among those might be a little bit difficult. But thank you.
Yes.
I'd like to ask the panel what they think about the conflict between the proposed registration requirement in a proposed statutory right of publicity and the fact that the right of publicity belongs to everyone. So the Facebook case would never have even happened if there was a registration requirement, because people who just have a Facebook account are not going to register their right.
Well, I think I see a distinction, and I'll defer to Professor McCarthy and other panelists, but between the statutory right of publicity that really is about commercialization and is created by statute, and the kind of right of publicity that you and I have now. And I realize Professor McCarthy has a little bit different view on that, so I will leave that to him to address. But there needs to be a way for you to get to people, right? If people want to charge, for the use of a persona, I think there just needs to be a way to find those people. It's particularly important for the post-mortem, I think, on an individual basis. That's, I think, where it can be most difficult, I think, to find the people. But I'm interested in other people's views.
Well, I think if it's a living person, you know who to go to for permission. So the only question is for postmortem rights, and some states do have a registration requirement. We do here in California. And that seems to me the only case where it would be unclear who owns the rights, who owns these estate rights, maybe that's been assigned to some agency, etc. So I think any model statute should have a registration for post-mortem rights.
Thank you both.
We probably have time for maybe one more question. Ooh, and someone is approaching the mic.
I have a question about the First Amendment. I wanted to direct this to you, Jeremy. You were talking about the different tests and how much muddle there is there. A couple of questions. First of all, is the right of publicity something that people like you at the studios actually like? Or is it more or less an impediment to clearance of things in films?
I think it's, speaking for myself,
Yeah.
it's something I don't like. I think if it is properly cabined with exemptions like the ones that Stacy was talking about, and there is an exemption in the statute in California that applies to the post-mortem right, then I think it limits it to what I think it was really designed to do. So when I say I don't like it, it's because of this problem of uncertainty in the expressive work area.
Have you given thought to what would be a more clear test for the First Amendment?
You mean if there's no exemption?
Yeah, if
But
there
the court-
isn't a stated exemption in this, well, there are stated exemptions in the statutes, but even if there are, there's always going to be the possibility that one could make a First Amendment claim, argument, defense. And as long as that possibility is there, we have to articulate some kind of a rule. And right now we have a mixture of balancing tests. We have the transformation test that you talked about out of California. And I've talked a lot to my students over the years about what would work.
Well, I think that the, as I suggested in my remarks, with all its imperfections, I think the way the law was under the Valentino case was basically working, and I think that the Rogers test is essentially at bottom a return to that. So I would advocate that the Rogers test is a good way of balancing it, and also with its no express misleading prong, it also takes trademark into account. It's a nice synthesis, I think, of the 43A and right of publicity. So the Rogers test, I think,
You'd
is
like the
pretty
Rogers.
good.
And if anybody else wants to weigh in on it, I guess what has always troubled me about the First Amendment use here is if the First Amendment wins, it means somebody else has the right to make money off of somebody's intellectual property. It's not just the right to make a statement and make speech, but it's a funny kind of First Amendment right? It's the right to profit.
Well,
Um,
I mean, the courts, the Supreme Court and other courts have dealt with that in all of these cases. It's in the Valentino case, it's in Supreme Court cases. Newspapers make money. We live in a capitalistic, profit-making society, so whether the defendant, the user, is making money has generally been rejected, and I think necessarily so in such a society.
Okay. Tom, you want to?
Oh, I agree 100%, yeah.
All right.
I think that the right of publicity has been pushed way too far by hungry plaintiffs' attorneys, far beyond what it ever was intended to do originally.
All right, well, as the hungry plaintiff's attorney, I will thank everyone for all of the remarks today, and we're certainly available for more questions throughout the day.